Sorry I couldn't be there today, everybody. I actually am being honored with an award, so it's a pretty exciting thing going on. But the case that I had was Gebser versus Lago Vista Independent School District, and it was heard by the U.S. Supreme Court on June 22nd, 1998. So, what happened was in 1991, Alita Starr Gebser was an eighth grade student. She joined a book club at Lago Vista High School, and during the book discussion sessions, the teacher in charge, Frank Waldrop, made a lot of sexual remarks to his students, not just to Gebser, but to actually all of them. But in 1991 and 1992, Alita was a ninth grade student and actually was in Frank Waldrop's class as a student. Frank continued to make sexually suggestive comments to Gebser and the other students in class. Waldrop initiated sexual contact with Gebser one day when he went to her house to drop off a book. For the rest of that school year and part of the next school year, Waldrop engaged Gebser in sexual relations, but never on school grounds, although sometimes it was during school hours. During this time, Gebser never notified school officials about the relationship. Another parent did complain about Waldrop's comments, and Waldrop was talked to about being inappropriate. In January 1993, police arrested Waldrop after Waldrop and Gebser were actually caught having sex. The board immediately fired Waldrop, and his teaching credentials were revoked from the state of Texas. At that time, the board did not have any anti harassment policy or an official grievance procedure, even though it was required by law. So the issue in the question in court conflict obviously was not over whether or not it was okay to have sex with a student, because it is obviously not, but rather it was over whether or not the school district was liable for damages. Gebser filed for sexual harassment damages, and the court was being asked to decide whether or not they were required to be paid by the school district. So after the case was heard, the Lago Vista Independent School District won, which means that it was decided they did not have to pay any sexual harassment damages to Geber. The Supreme Court ruled 5-4 under Title IX of the Education Amendments of 1972 that stated damages cannot be awarded in a teacher-student sexual harassment case unless the school official, and this is quoted, who at a minimum has authority to institute corrective measures, has actual notice of, and is deliberately indifferent to the teacher's misconduct. This ultimately means that as long as no school officials know about what's going on and do nothing about it, damages do not need to be paid. Now, there are previous cases in which a similar situation had occurred, such as Franklin versus the Gwinnett County Public Schools, but the major difference between the Gebser versus Lago Vista case and the Franklin case is that in the Franklin case, administration knew about the harassment and did nothing about it. Therefore, if the district is unaware of the sexual harassment or the sexual conduct between the teacher and the student, they are not required to pay damages. Thanks for listening, and I'll see all of you next week.